Okay, I think we've got a pretty good quorum here. A couple minutes after, so I think we can get started. Thanks all for joining. We will be recording this first part of the webinar. We will not be recording the audience Q&A towards the end. So just keep that in mind as you think about questions you might want to ask towards the end, and know that that will be kept within this group. Excited to have this conversation today. Excited in particular to have Matt Carmel here, who's been a friend of BPI for a while, and real expert on this subject. Pretty interesting timing too, not just in the wake of a relatively recent Supreme Court decision that we're going to be talking about, but also I guess the additional layer of intrigue now that the new or incoming administration I think will provide in terms of the role of agencies and what might be pushed to courts. I will let Matt introduce himself and his firm and get into the details of it. But again, as Matt is presenting and detailing a lot of this material, please keep in mind some questions you might want to ask him. There may be a little bit of back and forth between Matt and I have some questions I'll likely ask him following his presentation, but we want to make sure to reserve some time at the end as well. So with that, Matt, I'll turn it over to you. Thanks again for participating and excited to have this discussion today.
Thanks so much, Alex. Let me bring up my slides for everyone. Okay, how's that look?
Looks great.
Excellent. So thank you everyone for being here today and BPI for inviting me. I'm an environmental attorney and the practice group leader for the Environmental Sustainability Law Group at Offutt Kerman. I'll tell you a little bit about Offutt Kerman in a minute, but just about myself. As I said, I'm the head of the Environmental Sustainability Law practice area. My practice is very diverse. I represent large companies, small individuals, a whole range of things. What makes my specific practice unique is that we represent a lot of compostable products, manufacturers, a lot of composting industry people. I've been involved in the composting industry for almost a decade now, member of the US Composting Council, founder and board member of the New Jersey Composting Council. I'm also a contributing editor to BioCycle. So this is an area that we're involved in very much, and we do a lot of different things for the composting industry, all through the lens of understanding the industry very well. So the firm that I'm with is Offutt Kerman. It's a large law firm, full service law firm in the United States. We have 19 offices in 9 states, 280 attorneys. We're founded in 1987 and still growing very quickly. This is a slide that just shows the area of practices. As I said, it's a full service law firm, so we cover lots of different things. Corporate transactions, advertising, financial transactions, financings, banking, bankruptcy, international trade issues, all kinds of different things like that. I know that many BPI members are international or have an international focus, so I wanted to highlight that we have a very large international reach within our firm. We do not have offices outside of the United States, but we do have attorneys who are admitted in foreign jurisdictions and attorneys who speak a lot of foreign languages. We'll circulate these slides afterwards, so you'll get a sense for the different things that we can do, but we practice or coordinate with attorneys in a lot of different areas internationally as well. But we're here today to talk about the US Supreme Court's decision to overturn the Chevron doctrine, which means what? Right? Like, I think we've all heard that. We've heard a lot of pieces about that, but what does it mean? So Chevron deference is a doctrine that stems from the Supreme Court's 1984 decision in Chevron versus Natural Resource Defense Council. At its base, the decision states that if federal legislation is ambiguous or leaves an administrative gap, the courts must defer to the regulatory agency's interpretation if that interpretation is reasonable. So in other words, if Congress enacts a law and says, we're going to determine that this X, Y, and Z thing is false advertising, delegates that authority for rulemaking to the Federal Trade Commission. This is an example that's not exactly how things work. And the Federal Trade Commission goes and makes rules and guidance and interprets a statute that has been delegated to them. Up until recently, if the statute was ambiguous, what was delegated to the Federal Trade Commission was ambiguous, then the courts would defer to the agency's interpretation, to the FTC's interpretation in that instance. And that doesn't mean that that's the only instance where we get deference to agencies, but this is a one unique area where there are deference to agencies. There's also deference to agencies when they're making quasi-judicial decisions, like a factual decision or a technical policy decision. There's also guidance, case law about when an agency can use guidance and when they can't. That's not Chevron deference. Those are other aspects of agency deference. Chevron deference is this concept of if an agency is interpreting a statute that it's implementing, who gets to decide if that's correct? Who gets to decide if that interpretation is correct? So, Supreme Court in the last year made a key change to the doctrine of Chevron deference. We've heard a lot that Chevron deference is dead, that it's over, that it's been overturned. And that's too aggressive of a statement because deference still exists to agencies. But what has happened under the new standard is statutory ambiguity will no longer be deemed a congressional delegation of authority to the agency. In other words, the new standard rejects the presumption that ambiguity reflected congressional intent to delegate decisions to agencies. So, under the new standard, if an agency is implementing a statute and it's ambiguous, the courts are going to say, okay, did Congress intentionally intend to delegate the decision to the agency? If Congress intentionally delegated that decision to the agency, then Chevron deference still applies. It's just the agency will still be given deference and the ability to interpret that statute. What does that look like, right? Like if you had a statute that said, using the FTC example again, if X, Y, and Z is a deceptive marketing practice as determined by the Federal Trade Commission, that's the Congress giving the FTC the authority. They're delegating the authority to flesh out to the FTC what it means in that instance to delegate to determine whether something was a deceptive practice. If Congress did not explicitly delegate the decision to the agency, the courts are not going to defer and they're going to make their own decision, but they're still likely going to consider persuasive what the agency's interpretation is. So it's actually a much narrower change than it initially seems, but it is still substantial because of the way that our governmental system works. We have three areas of government. You have the judicial branch, and the executive branch, and the legislative branch. In other words, the courts, the agencies, and Congress. And given the amount of work that our government does, so much is implicitly or explicitly delegated to agencies. And historically, because this was not really an issue, most things have been implicitly delegated to the agencies. So the effect of this is that, for the most part, when we're looking backwards, if an agency is interpreting a statute, they're no longer going to get the deference there. It's interesting to think, okay, what's the impact of that, right? Like, who does that favor? And we're going to get to that in a minute. So you might immediately think that this new standard is going to benefit a certain group of people, but I don't really think it will. I think that it changes the playing field, and that's very important. But that playing field still doesn't really benefit any specific group, in my personal opinion. Let's take the industry from perspective. You're just changing the rules of the game, and that can benefit someone, but it also can just mean you're playing a different game. So let's take the industry from perspective, right? Like the industry is getting a little bit of power back, right? Because agencies are no longer going to be the ones who are always making the decision, but the industry isn't really getting the decision-making authority back. They are getting, in certain instances, they're going to be able to go to court and argue over whether this is a right interpretation or a wrong interpretation. And that benefits the industry if the industry is at odds with the agencies. If the industry and the agencies are aligned, then the old rules benefited the industry, right? So it's a question of how does this system work in a specific agency in a specific setting? Because all it does is transfer the authority in some respects from the agencies to the courts for these decision-making pieces. Public interest groups are in the same boat, right? They are going to have recourse to courts in this instance, and that may help them, may hurt them, right? If they have a friendly agency who's willing to make their interpretations, then public interest groups are going to be hurt when this new standard is used because they're going to have to fight to make those to uphold those standards before courts without Chevron deference. Agencies are the clear losers here, I think, a little bit, because they're no longer going to be able to unilaterally set policy where things have been ambiguous. But we'll have to wait a little bit of time to see how this is really going to impact them, because it may actually mean that agencies exercise more fluid authority than concrete authority. And what I mean there is the agency may not establish a firm policy on an issue because they may not want to be challenged. They may instead resolve to do this on a more fact-intensive, one-off sort of piece, like making decisions each time based on the specific facts of each case, rather than establishing a wide-reaching principle. And that may be the case whether they have a wide-reaching principle or not. So what I'm trying to convey is agencies may pull back on the clarity, transparency, and make decisions more in a black box and claim them to be more of these kinds of, you know, fact-sensitive decisions rather than black line. This is yes, this is no, this is black, this is white. We're also likely to see more guidance as opposed to rulemaking as agencies, realize, oh, we may not have the authority to do this in this different way. Congress, this is going to force Congress to be more clear about what they intend, right? And we'll have to see if that happens. So if Congress wants a certain definition to occur in a statute, they have to put it there. They can't rely on an agency to accomplish it. And they're going to have to think about, where is this allocation of power really going to be? The Trump administration is an interesting question, because I think a lot of people assume initially that the that because the Trump administration is part of the executive branch, that this is going to hurt the Trump administration because it's going to weaken their powers. And that is certainly true. But at the same point in time, it will also help the Trump administration because it will make them more able to have regulations that they don't like be challenged, changed, things like that. It's sort of very accepted in the legal industry that Chevron deference is not really a political issue. It's much more just a governance issue. And we'll have to see over time whether that falls apart and this actually does become a political issue. I tend to think that this is going to become a more political issue, especially when we get to how this works in states and how the states are different in this instance. But I think that that politicization is less about the topic and more about its connection to, you know, the belief that the Trump administration will deregulate. And so you'll have this back and forth between political parties over this issue, rather than it really actually being a tremendously political issue. So I used the example of the FTC Green Guides early on. What does everything I've said mean for the FTC Green Guides? I'm sure that most of you know the Federal Trade Commission's Green Guides are designed to help marketers avoid environmental claims that mislead consumers. This is guidance that is adopted by the FTC. There is no specific regulatory authority for this guidance. So the interpretation that we're dealing with here, because this is an interpretation of a statutory provision. The statutory provision is Section 5 of the FTC Act, which says that no business shall make a false or misleading claim, and gives the FTC the authority to enforce that. It does not really give the FTC the ability to decide what is false and misleading, to give them that discretion for that definition, which is certainly ambiguous and requires a lot of explanation and understanding. So the Green Guides, the FTC is not going to get much deference under the new standard. However, the guides themselves are not currently enforceable, and the FTC must prove that a challenged act or practice is unfair in any enforcement action. So this is similar to what I was mentioning earlier, that we're going to get more fact-intensive determinations. That's how the FTC already does this, yes. Yes, they have the Green Guides, which set standards, but when they go through an enforcement action, they look at the very specific facts and make a very intensive determination. How do these facts match up with, consumer surveys and consumer expectations and expert testimony and all of those pieces? However, so the current practice is consistent, likely is supported by the new standard after Chevron. However, the FTC is considering making the guides enforceable. This was something that they noted during their request for information to update the Green Guides in the last year or so. After Chevron, it's very unlikely to make the guides enforceable, because that would be establishing rulemaking, and that it creates a firm line that extends beyond the stated powers of the FTC. Now, I'm sure many of you have heard of, of the FTC's position on, it's escaping my mind right now, the point I'm making, well, the FTC recently engaged in rulemaking in connection with employment matters, and said that it is illegal to include provisions limiting the ability of someone to work after they've worked for you. So non-compete agreements was the word I couldn't remember for that time. However, and this was huge news because the US it's very prevalent to use non-compete agreements. However, court in Texas struck down the FTC's rules on non-competes, saying, especially after Chevron, this is outside of your authority. You do not have the authority to make this determination, so we're going to deny it. This isn't really how I expect the post-Chevron era to look like, of this kind of striking down these kinds of regulations, but it will be used in some instances like this. So everything we've been talking about so far has been about the federal government, and some things are federal and some things are state. The US Supreme Court decision only has an immediate impact on federal law, not state law. And so there are there are many laws that are at the federal level that impact the compostable products industry, but there are also many state laws. You know, instance, environmental advertising, like, excuse me, environmental advertising is regulated at both the state level and the federal level. I think that most of the environmental advertising claims that we've seen have been at the state level. In contrast, recycling, EPR, extended producer responsibility, labeling laws, those are primarily at the state level. So I would argue that from a regulatory perspective, from a requirements perspective, state law is much more important to the compostable products industry than federal law. 35 states currently provide substantial or appreciable deference to agency decision-making, meaning something like the old Chevron doctrine, and 15 states provide limited or no deference to agency decision-making, similar to our newer, standard. But even states that have disavowed deference may still rely on the pervasive value of their agency expertise. The question is, are the states going to follow the federal government, or are they going to go in the opposite direction? And this is one of the areas that I think this may get politicized, because I think that states may view this as a Republican issue now. And so Democratic states like California, like some of the East Coast states that are considering EPR now, may move away from the federal government's interpretation, the US Supreme Court's determination, and enhance agency decision making. I know we're involved in a large, appellate litigation on the East Coast, and we decided not to argue the Chevron issue in our appeal of that case, which involves agency decision making, because looking at the panel that we were before, they were very Democratic judges, and we thought that they would not look kindly on that argument, and it wasn't worth making. So it'll be very interesting to see how this plays out on different issues. This map from Bloomberg Law gives you a sense. All of the orange states have some form of Chevron deference in place. All of the other colors have some form of limited deference in place. And the colors denote how this has been accomplished. Florida passed the constitutional amendment. All of the light blue states had a state court ruling. All of the green states, this is by statute. And the dark blue state of Wisconsin is both. So it gives you a sense there's several different pathways to accomplish this change to deference. And I think we are going to see more states move that way, but I think we're going to see a diversion with some states entrenching agency decision making even more, and some states loosening that up. So we navigate agency decision making all the time for our clients. Whatever it is, whatever agency it is, we help them to either influence regulation and legislation that are being put into place, or once something has been put into place and there's an issue that comes up, helping them to figure out who to go to and what to do. So in the post-Chevron deference world, our 4 steps are: 1, assess the applicable framework, meaning, is this a statutory determination? If it's a statutory determination, has this issue been delegated to the agency, or has it been delegated to the courts? These questions, and there are many more of them in assessing the applicable framework, help you figure out what are the levers that you can and can't pull to make a change. And this is incredibly important, because beyond just what level of deference will be afforded to agencies if I were to challenge this, you need to know, okay, what are the pathways for the agency to work with me? What is already built into the regulation? Can they grant me an exemption? Okay, they can't grant me an exemption. Is there something else that they can do? Is there a waiver provision? Is there some kind of alternative compliance argument that I can make? Bureaucrats typically do not want to stick their neck out for anything. They want you to use an existing framework or precedent to move smoothly through something so that they're not subject to challenge by people who don't like what you're doing. So it's very important in the first instance to assess the applicable framework, determine what level of deference you're dealing with. Not that you're necessarily going to raise that deference at that time, because at this moment you're probably in a more collegial discussion with the agency, but it's very important to know for understanding what is your alternative to this negotiation process, to this collaborative process. But it's also, as I said, important to understand what are the different levels that you can pull, what are the different avenues. And all of this leads into what are the arguments and policies that you make? Those are informed by what the framework is, right? Like if you have to prove meet a specific criteria in a specific regulation, and that's the framework that you're in, you're going to focus your arguments on that. You're going to focus your policy points on that. You're not going to make a different type of argument. However, if there's no standard that you could possibly meet under the existing regulations, then you're going to focus on more broader challenges to the agency authority or to the enabling statutes or things like that. So this is informed by the framework and lets you figure out what are the levers to pull. At the same point in time, you want to understand what matters to the agency, right? What do they accomplish? We do a lot of work with the New Jersey Department of Environmental Protection, and we understand unless we prove that this is going to be as protective of environmental and public health as the alternative that we're proposing, we're not going anywhere. We're not, and there's several, you know, policies, positions, and even just public perception points that we know are no-goes with the agency. And so we have to address them every time that we go forward. Now, once you have the framework and the policies and the arguments sketched out, you need to determine whether you're at the right audience for the right arguments. And this is a critical step to the point that I was making a second ago. If you're making a hyper-technical I meet XYZ criteria and it's a scientific determination, probably your best part to be is at the staff level who is actually making that decision. And agencies are generally laid out, for those of you who don't know, in different levels, right? You have the frontline program staff who are the ones who are more program managers doing things on a day-to-day basis. And that goes all the way up to the head of the agency. And so if I'm going to make an argument that is not based on those kinds of technical criteria, but instead are based on this is going to kill an industry, this is going to look bad for the agency, right? Like it's never only those, but if that's really the gist of it, then I'm going much higher within the agency to make those arguments because the program staff level people that I'm dealing with, they're not going to be not they're not qualified, but they're not going to be comfortable making that determination. So you're going to go higher up. In any of these pieces, you always want to find common ground and find alternatives. What are the options for compromise? Because the agencies always are looking for compromise, and often they're willing to do something that makes sense. And that this whole process is about finding a way to do that. So with that, I think we're going to go to a little bit of question and answer, maybe Alex and I first.